The oldest building in a town is not a fort, it is not a palace, it is a place of worship. For hundreds of years, people have walked through its gates. Some came with folded hands, some came with prayers, some came with hope. But one day, a question changes everything. What was this place before it became what it is today? That single question has the power to change history, politics, law, and even social harmony. And this is exactly why India enacted one of its most important yet least understood laws, the Places of Worship Special Provisions Act 1991. But recently, the Allahabad High Court gave an interpretation that has sparked nationwide debate. Let us understand why. Picture India in 1991. Religious disputes over historical places were increasing. Communities were digging into centuries old records. Some claimed ancient temples had become mosques. Others argued that history could never be rewritten through modern courts. The government faced a difficult question. If every religious site became a courtroom battle, would India ever move forward? To prevent endless disputes, Parliament enacted the Places of Worship Act. Its central idea was simple. The religious character of every place of worship shall remain exactly as it existed on 15th August 1947. In other words, history before independence cannot become a never ending legal battlefield after independence. Only one dispute, the Ayodhya Ram Janmabhoomi case, was specifically kept outside the act because litigation had already begun. For every other place, the law intended to freeze the religious status. Simple. Or so everyone believed. Then came a new legal question. Suppose someone says, we are not asking the court to change the religious character. We only want to know what the religious character actually was. At first glance, these two sentences sound almost identical, but legally they are worlds apart. This distinction became central before the Allahabad High Court. The court observed that before deciding whether the Places of Worship Act prevents a lawsuit, it may first become necessary to determine the actual religious character of the disputed site. Think about that carefully. The court did not say the religious character should automatically change. Instead, it suggested that determining what the religious character is could itself become a judicial exercise. And that interpretation has attracted enormous attention. Imagine a doctor receiving two patients. The first patient asks, please change my blood group. Impossible. The second patient asks, please tell me what my blood group actually is. That is a diagnosis, not a treatment. Supporters of the High Court's reasoning say the court is merely diagnosing facts before applying the law. Critics disagree. They argue that once courts begin investigating the historical identity of religious places, the very purpose of the 1991 Act begins to weaken because every investigation itself can reopen old wounds. Now think beyond one single case. Across India, several disputes have emerged involving places like Gyanvapi in Varanasi and Sahi Idgah in Mathura. In many such cases, one side argues we only seek a survey, we only seek historical facts, we only seek judicial determination. The opposing side responds, but even beginning such an inquiry defeats the purpose of the Places of Worship Act. That is why the Allahabad High Court's interpretation is being watched so closely, because it may influence how courts decide whether similar suits can proceed, not by deciding who ultimately owns the site, but by deciding whether courts may first examine the site's religious character at all. Why does this matter for UPSC? Because this debate is much larger than temples and mosques. It involves three constitutional principles. First, the rule of law. Should courts have power to determine disputed historical facts when legal rights are contested? Second, secularism. Can India preserve religious harmony while also allowing judicial examination of historical claims? Third, separation of powers. Should Parliament's intention to maintain post independence status quo limit judicial inquiries? These are not merely legal questions, they are constitutional questions. The final outcome is far from settled. The constitutional validity and interpretation of various provisions of the Places of Worship Act are themselves under consideration before the Supreme Court. So the legal position continues to evolve. But one thing is already clear. The Allahabad High Court has shifted the conversation. Earlier, the focus was can the religious character be changed? Now the debate has become who decides what the religious character actually is? Sometimes history does not return with armies, it returns with documents. Sometimes it does not arrive carrying swords, it arrives carrying petitions. And sometimes the most powerful battles are not fought on the streets, they are fought inside courtrooms, where one phrase in a law can determine whether centuries of history remain closed or are opened once again. That is why the interpretation of the phrase religious character under the Places of Worship Act has become one of the most important constitutional debates in contemporary India.